See, there's another there's a website here about the suffragettes. English legal history. Makes me wonder who these people are who make these websites and write them. There's so much misinformation. It's obvious now, even now in the most modern time, with all the digital communication and websites and groups and, like you can put messages on boards and things and speak in groups and forums, that I'm recording this video now even. I've got all the books on my shelf with all the actual law in. The legislation speaks for itself, right? But we've got all these campaign groups in the courts getting prosecuted still. Extinction Rebellion, Defend Our Juries, Just Stop Oil, Insulate Britain. And they're just doing these common law defences, and it's just an echo of what was happening here, right? Here is a bit of a brief history about the suffragettes, right? Going back, this is mainly to do with the history of voting. There's a picture of old Parliament there. Tells you quite a bit about voting history. And then when we get to here, look, this is one of the suffragette women, Emmy Pankhurst. This is what this website's written. This is what they're saying. Despite being well known for militant action, the suffragettes had carried out a great number of peaceful attempts to publicise the struggle of women's suffrage. That means that they'd actually been petitioning and collecting signatures and trying to get an action through government lawfully, which is what everyone usually has been doing. But currently the Petitions Committee are rejecting a lot of petitions and won't let a lot of them run. And even those who are successful and get a lot of signatures don't even get an action. Look at Michael Westwood. He's got 3 million signatures. It's more than anyone could ever dream of. I think it's up there with the top petitions ever. It's even calling out the Labour Party for lying in their election campaign. And we haven't even got a public inquiry from that. If that doesn't appear to a minister to justify having a public inquiry, I don't know what does, right? Because public inquiries have been run on a lot less than that. When the whole government are, the cabinet and the speaker and the prime minister are all Labour Party, they're just protecting themselves and their own party, which surely is definitely a breach of impartiality for sure. But anyway, the suffragettes were having the same problems, and they weren't even getting anywhere as near as Michael Westwood was getting in his petition, or has now on his petition, right? So now it says, right, the militant action was largely in response to these peaceful attempts being ignored and undermined by men in power. Well, we've now got women in government and they're still being ignored. We've got women, we've had women as the Attorney General, we've got a woman Chief Justice, right? And they're still being ignored. And the way that the first public order act is written is meant to figure in for these privileges. I don't think that all these people were that knowledgeable about the law even back then. And people knew about privileges because, Herbert Broom's writing about it. And then you got all the Parliamentary Papers Act and so forth. I mean, even newspapers are getting privileges acknowledged now for sharing certain things, but not protesters, when it's effectively the same thing because you can share it by word of mouth or sign. Now that the petitions are actually published on the government website, the effects of them can't be prosecuted against. And I know that Extinction Rebellion and Just Stop Oil are pushing it by, using a lot of paint and other things being done. But some people, like the Stop ULEZ people, weren't actually doing that. They were just appearing in public and advertising, and they're getting prosecuted for the effects of the advertisement on, like the Mayor of London, for example, who they're opposing. That is what the basis of the Parliamentary Papers Act covers. A newspaper can have a newspaper stand or a newspaper boy going around with a newspaper, reading it out, or even writing it. They're protected with privilege. So, how can the people who are doing the petition in the first place that gets into the newspaper, when it's a published parliamentary paper, it what's actually happening now is scandalous, because the people getting prosecuted when it clearly is absolutely privileged. This also talks about, it's 1908, so they just made the Public Meeting Act as well, when you're allowed to assemble in public and not be broken up or prevented from transacting any information between a group and the public, or within a group. So what it's effectively saying are, these women start resorting to, things like when they went to the race course and she's trying to fasten something on the king's horse, she gets run over. Now, this is what it says. Firstly, in 1908, well, that's when they made the Public Meeting Act in 1908, Mr. Musket was successfully prosecuting a group of suffragettes in the Westminster Police Court. Doesn't say what he's prosecuting them for, which offence. It doesn't say that they're claiming privilege, or they particularly knew about privilege, or whether he wanted to recognise it. Because remember, if this Mr. Musket was acknowledging that he was prosecuting them illegally, unlawfully, and if they did claim privilege, then he would be in contempt, right? So it's not giving the full details here. The group were sentenced to 2 months in prison and a £5 fine, a common punishment that was levied many times against the suffragettes. Well, prison's quite serious. That's serious. £5 fine might have been a lot of money back then, but 2 months in prison is quite serious. Any prison sentences. It doesn't say what they were charged with. And that was levied many times against the suffragettes, right? But I've got a feeling that not all the suffragettes were clued in on what was going on. Just like, effectively, it's almost like a repeat in history, like Gail Bradbrook now and Claire Farrell. And I think that they've probably read a lot of these websites and pages of Gail Bradbrook and Claire Farrell, and they've probably been this is propaganda, right? This is a website written by someone who doesn't. They're not giving the full facts, and I don't think they actually know the full law properly, and I don't know who they are. I mean, I don't know whose website this is, but if they're anything along the lines of Malcolm Jack or any of these people in the committees of Parliament, they're giving a lot of misleading information. In fact, the Committee of Privileges have lied in the paper. They actually tried to pass off a statement, a well-known statement, as legislation, right? They tried to pass off like Article 9 of the 1688 Bill of Rights. That like this is Article 9 of the 1688 Bill of Rights, right? Instead of putting what the article is, they basically put a comment of what someone in Parliament thought it meant. But it says Article 9 of the 1688 Bill of Rights. It's almost like saying here is, a bottle of milk, but it's not a bottle of milk, I don't know. Well, I do know. What they're doing is, the words that they wrote, they said, behold, here is Article 9 of the 1688 Bill of Rights. And then what it was, no, that's not Article 9 of the 1688 Bill of Rights. That is an interpretation of it, right? Or someone's idea of, what it effectively means. But, they'd entitled it. They'd entitled it like Article 9 of the 1688 Bill of Rights, but it's not, right? Mr. Musket, so this is, remember they didn't have a Crown Prosecution Service then, so this is just like a prosecutor who'd been appointed by the police, right? Warned the group that if they offended again, he would seek to use the long dormant Tumultuous Petition Act 1661 against them. I don't think it was long and dormant. Now, this is the thing. Clearly, they hadn't used the Tumultuous Petitioning Act themselves, which means that if they had, they would have all been covered by privilege, right? But had one of the suffragettes used it, I read a story that one of the suffragettes handed a petition into Parliament and hid it under a cart or something, and like smuggled it into the MP. It sound like that makes it suggestive that they didn't get consent or permission from the courts, right? But what's actually happening in this account, in this story, is depending on whose website it is and what they know and don't know, and where they get their information sources from, it's all like a succession of redacted information, not the full details and accounts that are needed to be known for clarification. And this is what's happening now in groups. People are like, there's, you know, you've got like people like Lawrence Fox, for example, who got arrested. He didn't really properly understand the law and rights properly. You got Mike Amesbury's been arrested. Suella Braverman even got a speeding ticket. Dan Norris, and they're not applying the 1770 Parliamentary Privileges Act properly when there's full access to the law online. All these acts of law are online. You can read them in great detail. They're all at the fingertips. That wasn't the case back then, getting hold of all these books and the knowledge. And people are talking in groups, but people are talking in groups and there's loads of misinformation flying around, and then people are misinformed, and it's a lot quicker and easier to be misinformed now. And there's all these court cases going on which are completely wrong, and there are all these wrongdoings in Parliament as well. And you can email Parliament, you know, with a click of your fingers. You don't even have to buy a letter. And these people are just absolutely defiant. I don't even think the Attorney General is lawfully in place at the moment, because, you know, there's a conflict of interest between the privileges of the Commons and the Lords, right? And the Attorney Generals were given peerages as a reward for serving as Attorney General, not in order to serve as it. And it's a committee of it's meant to be a committee of the Commons, that committee. We'll continue reading this, right? So a barrister who's prosecuting these suffragettes is threatening to use a tumultuous petitioning act, but like William Penn, right? But it wasn't. But what sentences they've got seems harsher than what William Penn got. And if he wasn't using the tumultuous petitioning act, what was he using to prosecute them? It doesn't say what the offence is. Is this some kind of like criminal damage or breaking fences? You know, was it one of the Metropolitan Police Act offences, carrying placards in public? Those acts say that privileges apply. Did these women even know what privilege is? Was it to do with an excess of 20 people being in public together, supporting a cause? That wasn't supposedly what he prosecuted them with, right? But if it was less than 20 suffragettes, then and they were advocating this cause, they might be privileged anyway. Now, if this Mr. Musket was prosecuting them unlawfully, then he's committing a contempt of the High Court of Parliament, right? But remember, at this time, the Thomas Erskine May book was in its early stages, right? This is like 1908. I don't know when the misconduct against petitioners section in that book. I've got the 1946 and the 1964 version, which both have misconduct against petitioners, right? Now, I don't know in 1908 if that section had been inserted, which has got a lot of clarification and detail in there. But for sure, 1908, they definitely had that Herbert Broom book was about. Maybe these suffragettes could have done with getting Herbert Broom, but you know, who's none of these current protested groups, they're all getting criminal defence lawyers. None of them are getting constitutional law people, and all these public order law people aren't claiming or using privileges. They're not claiming privileges. They're not even using the Parliamentary Papers Act, which I'm just absolutely, because you don't even need to get any documents or certificates for that act now. And a lot of the newspapers are effectively doing things when they report on Parliament that it's advertising, it's giving notice to the public, announcements and so forth. And a lot of these groups are not even using that law, which even the newspapers can claim it when they're not even doing a petition, right, to be privileged. So I don't know whether, my messages are getting blocked. A lot of these groups they've got a lot of people behind them, but they're all kind of scatterbrained, and they're making the wrong representations in the courts. They're not saying the right things. They're not bringing the right claims, and there's so many people behind them that they kind of like, in a way, they've got all this Dutch courage and they think they're invincible and they're doing all these actions. And, if we've got 10, they're like, if we've got 100,000, 200,000 followers, how can we be wrong? All these people behind us going out and doing all these actions, they truly believe they're at the forefront of it, on the front line, but they're not, because they're in prison or they're getting arrested. If we've got 10,000 people behind us all turning up to protest or doing this or this or that, what can we possibly be doing wrong? Don't advise us or tell us about the law, because, we've got so many people here that, we know, but they don't know. And I think it's the full force of this ignorance, which is kind of like putting them on this path of incorrectness in the courts. And this involves contempt. What we're dealing with here is police, crown prosecutors, and these justices who are doing something against these citizens, which is a very serious crime in itself. So they're not going to confess and admit it. So we've got a very serious problem. But anyway, this coming back to this article here that we're looking at, doesn't say what they were prosecuted for. Doesn't say what the charge is, right? He's not charging them for a tumultuous assembly, right? Because then he would have to admit that there was a petition, right, or an address to Parliament, which was privileged, but they exceeded the limited number of people, right? There's something about this which is peculiar. Mr. Musket warned the group that if they offended again, but to what offence? It doesn't say. Just for being together in a group, or did they damage something? It doesn't say. He would seek to use this act, which he wasn't using, right? The 1661 Act was a remnant from the time of Charles II and stated that a group of no larger than 10 people were allowed to petition the monarch or the House of Commons. Well, that is completely and totally wrong. This is wrong. This is false. Whoever wrote this website is talking absolute complete tosh. I don't know where they're getting their information from, who this legal history website is. Is it propaganda? Is it part by the government? It's nearly as bad as the Privileges Committee report, right? So this is just wrong. It's 10 people are not allowed to hand the petition in to the King or Parliament in person, right? That means a group of 10 people. But that even if they're not allowed, they're allowed to have 20 people supporting it, the petition, right? And they can't have more than 10 of them. Now, were they trying to hand it into the House of Commons? Was that the offence, right? If they had 20 people, but 10 of them were trying to hand it into the House of Commons or whatever, then, that's an offence under the Act. But what these people are trying to do is they need to get a very, very large number of signatures and advertise and promote the cause, right? And you couldn't do that without going through the court process. But that attaches the privileges to more than 20 people. And then this Mr. Musket wouldn't have been able to prosecute them. So this 10 people thing is only for actually physically handing it in. But so if a group, they were liable to a sentence of 3 months in prison. The 1661 Act was a response to the many violent petitions brought outside the House of Commons towards the climax of the English Civil War in 1651, which led to the execution of Charles I. The right to petition the monarch and the House of Commons is a long-established right in the legal history and stretches back at least to the time of Henry III. So, if he wasn't prosecuting under them, under that act, I don't know what he was prosecuting them under. 1908 is when they made the Public Meeting Act, when you cannot be broken up or prevented from transacting information. The right to petition is the way, in this way, was enshrined in the 1680 Bill of Rights, which was seen by some as a de facto repeal of the 1661 Act. Unfortunately, the 1661 Act was not formally repealed until the implementation of the Public Order Act 1986, right? Well, Herbert Broom says that, yes, the tumultuous act was kind of like regarded, it was kind of like regarded as a bit of a, well, it says a dead letter or a joke or whatever, but it was still in effect. But the thing is, they're not officially going to get the protections the proper way, by the sounds of it. Emmeline Pankhurst wished to test Miss Musket's assertion, and the day after the successful prosecution, she brought a group of 13 suffragettes to Parliament to petition. So what she's doing is she's going against the Act then. So they're getting like groups of 10 people together outside Parliament, not to the King. Now, the Public Meeting Act said that you can't be broken up in a group as long as it's lawful. But if it is an address, if it is a proper address to Parliament on a cause, then you need permission. Well, they won't get it. I don't know why they didn't get it. You'd want to do that. A prosecution under the 1661 Act would require a full trial before a jury, something the suffragettes desperately wanted, as many members of the public were sympathetic to the cause, rather than a closed trial at the police court. Mrs. Pankhurst was arrested on her approach to Parliament and tried in the police court. Sadly, no reference was ever made to the 1661 Act. What did they prosecute her for then? What did they prosecute her for then? No references. Well, this is what they're doing now. They're prosecuting them and they're not giving any reference to the 1688 Bill of Rights or privileges or even petitions, right? They're just prosecuting people for offences under normal common law. So it doesn't seem like much has changed. They had that act and there was a special process, but it doesn't seem like from this that they were going about using it, or not all of them, maybe some of them. Second, much of the earlier suffragette work revolved... It's sounding like, because of the 1688 Bill of Rights, that you can't be prosecuted, they might have sort of like been kind of like a little bit ignorant or defiant of that 1661 Act. If a lot of people had the attitude that the 1688 Bill of Rights should, stop you from getting prosecuted, they weren't bothering going about the other procedure. But if they had that procedure, why weren't they doing it? Well, why aren't we doing it now? Well, because it's been repealed, right? But theoretically, you could go to a county court now. What Extinction Rebellion and Just Stop Oil could do. I mean, this is all like money and things like that, but they're really organised and they've got loads of people, but they don't seem to listen. Effectively, you could go to a court now. Extinction Rebellion could say, right, all right, we're Extinction Rebellion. We've got all these causes to Parliament, right? And we want the justices to, get their seal and agreement to attach privileges to it because it's meant to be privileged. And you know, we want the Protection of the Parliamentary Papers Act in all our advertisements, right? And they could go in the court and get an order, and then when any of them get arrested or these charges, then they get the court order out and say, we're privileged, right? You could do that now, I think. Although you don't have to, but the process has been repealed. But there isn't anything stopping you from doing it, and that's what I've started to think now. You know, why don't I go get an order? Which I could have done. I probably could have done that before I started, and I wish I had done, but I didn't know all this at the time. Secondly, much of the early suffragette work revolved around campaigning in areas where parliamentary by-elections were taking place in an attempt to de-seat current Liberal parliamentary members and upset the status quo. In 1908, a 30-year-old Winston Churchill was promoted to the government cabinet of becoming the president of a board of trade. Any new cabinet member to go through? Emmeline Pankhurst sought to campaign against him, and part of Mr. Churchill's response was to hold a woman-only event, assuring the women of Dundee that he would seek women's suffrage in the next Parliament. Mr. Churchill won the seat. This must have proved an interesting early political tumult for a man who would go on to serve 2 terms as Prime Minister. He won the seat. He held a women-only event, assuring the women of Dundee that he would seek women's suffrage. Why is that a tumult then? Never seen a picture of Churchill before looking so young, actually. Look at that. Further campaigning and political pressure led to the introduction of the Representation of the People Act 1918, which granted the right to vote to all men. So effectively, they're saying that they were turning up in groups of more than 10 outside Parliament. Well, that's an offence under the 1661 Act, right? So why are they saying that this prosecutor, Mr. Musket, why if that's the effect, why isn't Musket using the Act to prosecute them? Why is he threatening to use it and not using it? Then what's the offence? Doesn't make sense, does it? 1908 is the year that the Public Meeting Act was enacted. So I'm quite certain. There's a lot of photographs of suffragettes going around. You know, there's large groups of women, but although a lot of the time they're in groups of about 10, they're not telling us the whole truth about this period. It would be interesting to see the actual full court records and exactly what happened. And because I've got a feeling that there were some people who didn't really know the law and they were just kind of like going along with it now, like Extinction Rebellion and Just Stop Oil are. They know what the right is, but they're just refusing to. They're coming out with all these common law arguments, and I think a lot of them have given up with getting solicitors now. They were getting all these solicitors and barristers, but now they're sort of giving up with them. But they're still not using the right language and saying the right things when they go into the court. And Extinction Rebellion's so big, and Just Stop Oil's so big, and they've got so much funding that it's extremely easy for them, and they're really motivated, and they're in and around London, to actually just go into a county court and get it all settled. But they won't for some reason. And I think that's what you need to do when you're not on the defensive side, right? Because when they're getting prosecuted for all these things, you're on the defensive, and someone's trying to either fine you or get a charge against you, right? But when you're not on the defense, when you're like, okay, we're going for the proper procedure now, let's get this sorted, right? But there are so many acts now, like the control of advertisements, which actually says, right, okay, insert what act of law that you're using for what it is you're doing here. And then you've got this Parliamentary Papers Act and then all the updates of that. But even now, YouTube are not even acknowledging that, because what you've got now is we've got the law, but then what happens is you've got this big entity called YouTube who come in and say, oh, well, we've got these policies and you've got to agree to these policies, but they're not the law. And all the things that were legal in the newspapers and had privileges and protections now we're going to kind of subvert, undermine and ignore that by saying, hey, we're this big entity called YouTube and we couldn't give a chuff about what your laws are. We've got all these Section 230 immunities and all this stuff, and we can do all these things, which the laws meant to facilitate. And it seems like the authorities and these big corporate entities are always one step ahead of, even now when we've got all the legislation, we've got the websites, we've got all these laws, we've got the Parliamentary Papers Act, and we've got all the acknowledgements of privilege. But now it's like, well, we're beyond the law. It's like what Charles said, beyond leaders. It's like YouTube and all these platforms are like, now we've learned the law, and now what we know all the privileges and rights are. Okay, let's go. And we'll, let's do it. Oh, no, we can't do it now because we've got these big entities who say, oh, screw your laws. We've got a policy, right? And I'm like, what? It's like, what of a surprise are they going to pull out of the pocket, right? Hey, now we know and learn the law, and have got all the laws, and you're the criminal because you're in contempt. Oh, but now we pull the next trick out of our sleeve, which is, hey, the policy. What are the Department of Culture, Media and Sport doing? My channel's been taken down. That's evidence. I'm in a modern day of technology and communication with emails, departments, the Advertising Standards Authority, Ofcom, all these facilities that we're paying for the taxpayer, and they're all completely in contempt and undermining the law, and they won't do anything against YouTube. And we don't even have that Section 230 in England. It doesn't even exist, and we're not getting any support or help at all. People are getting prosecuted, not even for breaking anything or painting anything, just for literally being there and promoting the cause, which that is absolutely not breaking the law, and it's completely and totally protected. But then we've got this Maryland Sadiq Khan, and then he's just been knighted by Charles for being in contempt against protesters. What? It seems like this current government aren't about truth and honesty. They're about supremacy, right? I think this government are about supremacy. So why have a complaints department? Why have standards? Why have laws? It seems like they're just wanting to use and implement them as their own personal tools to use law against the people. And if the people say, just a minute, but you're not following the law, then we don't care. It's supremacy, right? There's some kind of supremacy model in effect at the moment with the Attorney General, with the Prime Minister, with the Speaker of Parliament, with the Chief Justice, with the courts. What's happening is supremacy. And the public seem to be, even with all the modern technology and communications, just there's a lot of misinformation still going around. So they're not able to focus and clarify and really challenge on the points that need challenging on.